Hi and welcome to SQE Success, your pathway to becoming an English solicitor. In this question bank series, we'll look at 3 questions in relation to destruction of a will, which falls under wills and administration of estates in FLK2. Let's dive in. Here's the first question we tackle today. A few years ago, a man made a will in which he left his entire estate to his wife, explicitly excluding his adult son from a previous marriage. A few weeks before his death, the man read an article about the rules of intestacy and mistakenly believed that his wife would inherit everything automatically, even without a will. Acting on this misunderstanding, he destroyed the will. He died shortly thereafter. What is the legal position? A. The will is not valid because the man had the intention to revoke at the time of carrying out the act of destruction. B. The will is valid because the doctrine of dependent relative revocation will apply. C. The will is not valid because it was destroyed and is no longer physically available. D. The will is valid because the mistake was as to the legal effect of the will. E. The will is not valid because the presumption of destruction will apply. You can pause the video and think about it. The correct answer is B. The will is valid because the doctrine of dependent relative revocation will apply. The doctrine of dependent relative revocation, DRR, applies where a will is revoked under a mistaken belief about the legal consequences of doing so, and it can be shown that the testator would not have revoked the will but for that mistake. This principle was applied in Estate of Southerden, 1995, where the testator destroyed his will believing it was no longer necessary due to a mistaken understanding of intestacy law. The court held that the revocation was conditional on a mistake and applied DRR to uphold the validity of the destroyed will. Similarly, in this scenario, the man's intention to revoke was based on a misunderstanding of the law, and the court is likely to treat the will as not revoked. Let's look at another question very similar to the first question. A woman made a will 5 years ago leaving her estate equally between 2 close friends. Recently, she had a falling out with one of them and decided she no longer wanted that person to benefit. She told several people she planned to make a new will, this time leaving everything to a charity she supported. Acting on this decision, she destroyed her existing will by tearing it up. However, she passed away suddenly a few weeks later, before preparing and signing any new will. What is the legal position? A. The will remains valid because the testatrix only intended to revoke it once a new will was executed. B. The will is not valid because it was intentionally destroyed with the intent to revoke, and no valid replacement was executed. C. The will is valid because the doctrine of dependent relative revocation applies where a new will was contemplated. D. The will remains valid because revocation must be in writing and signed by the testatrix. E. The will is not valid because there was no intention to retain the original beneficiaries. The correct answer is B. The will is not valid because it was intentionally destroyed with the intent to revoke, and no valid replacement was executed. Revocation of a will requires an intention to revoke, coupled with an act such as destruction. In this case, both elements are present. The testatrix intentionally destroyed the will with the express intent to replace it. Merely intending to make a new will is not sufficient to make the revocation conditional. This position was established in Re Jones, deceased, 1976, where the court held that a testatrix who tore up her existing will intending to make a new one, but died before executing it, had validly revoked her previous will and died intestate. Here is the third tricky question. A man made a will leaving his entire estate to his only son. Months later, following a serious quarrel, he tore the will in anger and told a friend that he no longer wished for his son to inherit. A few days later, the man reconciled with his son and expressed regret about destroying the will. He attempted to repair it by taping the torn pieces back together and placed it back in his drawer. He did not make or sign a new will. He died unexpectedly 2 weeks later. What is the legal position? A. The will remains valid because the taped document still reflects the testator's final intention. B. The will is not valid because it was destroyed with the intention to revoke and cannot be revived by taping. C. The will is valid because the destruction was impulsive and not accompanied by settled intent. D. The will is not valid because it was not re-executed after taping and is no longer in legal form. E. The will is valid under the doctrine of dependent relative revocation due to the testator's change of heart. The best answer is B. The will is not valid because it was destroyed with the intention to revoke and cannot be revived by taping. Revocation of a will by destruction under Section 20 of the Wills Act is effective if there is a clear act of destruction with the settled intention to revoke. Here, the testator tore the will during a dispute and expressed an intention to disinherit his son. That is sufficient to constitute valid revocation. Once revoked, a will cannot be revived simply by repairing or taping it back together. Revival requires re-execution with the proper formalities under Section 9 of the Wills Act. The testator failed to execute a new will or re-execute the repaired one, so he died intestate. Here is the summary of legal principles. When a testator revokes a will based on a mistaken belief about the legal consequences of doing so, e.g., assuming intestacy will achieve the same result, the court may treat the revocation as ineffective. The doctrine of dependent relative revocation applies where the revocation is conditional on a false assumption or intention. On the contrary, DRR did not apply where a testator deliberately destroyed his existing will intending to replace it, but died before executing a new one, because the revocation was not conditional on the new will being signed. Finally, destruction of the will with intent is final unless re-executed. A revoked will cannot be revived by taping or restoring it physically. Have you noticed how a slight change in facts, such as the intention of the testator when he destroyed the will, can lead to a completely different legal outcome? That's exactly the skill the SQE tests, and mastering it is key to exam success. I published books filled with MCQs, each built with 3 variations of a legal scenario to sharpen your analysis and deepen your understanding. It is a must-read to pass SQE 1. Turn your ambition into qualification. Begin your SQE journey to become an English solicitor.